Hi y'all, I'm Jeff and I'm a patent attorney. Thanks for joining me today. If you've started researching how to file a patent, you probably hit two confusing terms: provisional, non-provisional. People often think they have to choose one over the other. The truth is they work together, and knowing how can save you money and protect your timeline. Start with the provisional. A provisional patent application is essentially a placeholder. It's not examined, it never becomes a patent on its own, and the USPTO won't review your claims. What it does is establish an early filing date and let you say patent pending while you keep developing, raising money, or testing the market. Here's the catch. A provisional only lasts 1 year. Within that year, you have to file a non-provisional application that claims the benefit of the provisional. Otherwise, the provisional expires and you get nothing from it. So a provisional doesn't extend your protection forever. It starts a 1-year clock. The non-provisional is the real application, the one that gets examined and can actually mature into an issued patent. It requires formal claims, meets stricter requirements, and is one an examiner reviews. If the provisional is the placeholder, the non-provisional is the main event. Now, the most important and most misunderstood point: a provisional only protects what it actually describes. If you file a quick, sloppy provisional and your invention is more developed by the time you file the non-provisional, the new material does not get that earlier date. A cheap, thin provisional can give you a false sense of security. Done well, it's valuable. Done carelessly, it can be nearly worthless. And another point, if you add material into the provisional that limits the application, that material also limits the non-provisional. So which do you file first? Often, a well-prepared provisional makes sense. When you want an early date, need time to refine or fund the invention, or plan to file internationally later. But provisional first is only smart if that provisional is done thoroughly. The right path depends on how finished your invention is and what your business plans are. That's a quick conversation worth having before you file either one. Thanks for joining me. Until next time, you can get more information on patents and intellectual property generally at ideashield.info. This video is general information, not legal advice, and does not create an attorney-client relationship.